Good morning, Your Honor. Charles Goodwin, bar number 14879, on behalf of Mr. Cintron, who should be present via Zoom. He lives out of state, Your Honor. I think we mentioned it.
Mr. Cintron, are you there?
Yes, Your Honor.
Okay, good morning.
Morning.
So defendant Cintron's writ of habeas corpus, the state's return. One question I had right off the bat, and it could be that I did review them, but I am in trial. So is racketeering out?
Your Honor, so in a conversation that I had with Mr. Goodwin, the state is going to refile an amended superseding, and we're only going to be proceeding on conspiracy to commit murder.
I thought that might be the case,
Yes,
but I wanted to
yes.
make sure. Okay. So really, you know, the issue then is the conspiracy. So I reviewed the writ, the return, probably inclined to deny the writ, because I think there's, you know, that low bar of evidence, but welcome arguments.
Yes, Your Honor, and I appreciate that. And I would like to point out that the state actually mentioned something that I think is very important. An agreement is all it takes, regardless of whether any act is taken out. I agree with that statement. However, in this instant, an act was carried out. And Mr. Cintron was not part of that act. He's not charged in it. He's not cited in it. That then raises the question, what agreement was he part of? Because I cited to the case law that explicitly states conspiracy requires an actual agreement. And if somebody thinks they're in agreement, but they're not in agreement, then it doesn't count as a conspiracy. So whatever that was happening prior to that, and then they actually had the act carried out and he's not a part of that situation, I don't see how the conspiracy still stands, because clearly there was conversation, if there clearly was a plan, how he would be a part of that when the attempt and the actual everything else that followed on that, he's not listed as a defendant there. That's number one. Number two, I think there would also be an issue with the conspiracy, because if there was a conspiracy that existed, according to the grand jury transcript, it would have been when he was being pursued by the complaining witness in this case. That would have been when the conspiracy was established. However, what happens is that person's car is disabled. They're left on the side of the road for 15, 20 minutes, according to testimony. And when they arrive at said location, he's no longer being followed. So I think that whatever conspiracy there would have been done at that point if he had followed and they had gone to the location and this had occurred. I think that's a different conversation that we're having. However, Mr. Cintron was not aware that there was a tracker placed in this car by this complaining witness, who then took it upon himself to bring himself to this location. He was not baited. He was not told to come here. And through the whole entire incident, Your Honor, at no point did Mr. Cintron initiate this whole entire action. This other individual initiated everything that occurred this day. He's the one who followed them and stopped them multiple times. He became very aggressive, at one point reaching into the window. He blocked their car on an on-ramp to the freeway. Your Honor, that's incredibly dangerous behavior. They ran. And I don't see how we're going to get to the conspiracy if this individual is taking it upon himself to bring him there unbeknownst to Mr. Cintron. Because it was clear that they knew they were no longer being pursued at some point, because they arrived and there was no one behind them. There was no one following them on the freeway. There was no one following them on the streets. This individual took it upon himself. So I think that there's two arguments there. One, if there was a conspiracy, which we deny there was, it would have been any conspiracy that would involve him following them to that location. And number two, there couldn't have been a conspiracy that Mr. Cintron was a part of, because he was not charged in the attempt. For those two reasons, Your Honor, it's just logically inconsistent to hold him for conspiracy but not attempt when he's allegedly present when this whole incident occurs. So, Your Honor, with those two, we would request dismissal.
Thank you very much.
Your Honor, and I'll just briefly respond. Essentially, those same arguments were raised in the petition. The state responded to those. I would submit to Your Honor that there's no time limit on a conspiracy. I mean, a conspiracy to commit murder can be committed weeks, months before an actual murder occurs. And nonetheless, Your Honor, the actions and conduct rarely, I would say, at least I've never had a case where a conspiracy is proved because we actually have a written agreement. It's inferred from the conduct and actions of the individuals. And here, none of this happens but for Mr. Cintron ultimately calling his people as testified at the grand jury by the witness who was in the car, directing her to go to a specific location. And then lo and behold, when the victim is lured there, we know what happens after that. Certainly, it was enough evidence that the members of the grand jury believed that there was slight or marginal evidence, that there was some sort of agreement that this crime occur. Based on the fact of how it all happened, how it was all orchestrated, that the conversations and the information that was received by Nelson Cintron were from Ethan Cintron. So nonetheless, Your Honor, I believe that there was slight or marginal evidence of the conspiracy to commit murder. Just because he's charged in the conspiracy doesn't mean he actually needs to be charged in the attempt murder. The conspiracy is the agreement. That's the crime. And I'll submit that there was slight or marginal evidence of that agreement being made and presented to the grand jurors.
And if I could just briefly,
Yeah,
Your Honor.
sure.
The state said he called his people. I want to be very clear. He called his dad. He's a 19-year-old kid being confronted on the road multiple times. He called his dad, and his dad said anything that a dad would say in this situation, come to me. Whether or not there was anything about this is there's no evidence that happened. And I understand we have to have the circumstantial, but there was a tracker in his car, and that individual followed him. So I don't think they've met that. I don't think that what this agreement would have met that. And I would push back on their. I do agree there is no timeline on murder, but I would push back on what we're kind of implying here, because if we're saying here's the plan, say to poison X. And then later, a fight breaks out between 4 individuals, one of them being part of the conspiracy, and that individual strikes him and kills him. Would we say that the other people who agreed to poison him would be part of that conspiracy? No, because it's a different act entirely. And I think that whatever was planned, one was planned without Mr. Cintron's knowledge. He was calling his dad in an act of fear. And number 2, that whatever plan was contrived was not something that he was still on board with as he had made it to safety.
Thank you very much. So as to the racketeering portion, we'll call that moot, given the state's agreement to remove that, but put that in the order. That way we know that portion. As to the conspiracy, I'm going to deny, slight or marginal evidence, circumstantial evidence, we know what the alleged conspiracy or agreement, we know what has been alleged, and there's slight or marginal evidence, circumstantial evidence support of that. The fact that defendant was not charged in the actual attempt does not necessarily follow that there was no conspiracy or that he was not part of a conspiracy. So for that reason, that portion's denied based on, slight or marginal evidence, circumstantial evidence. So at the state, if you could prepare that order. Anything else?
There you are.
Thank you. Thank you, sir.
Thank you, Your Honor.